Mr. Truce, do you have Ms. Albright and Mr. Barshaw?
Mr. Barshaw is ready. Ms. Albright contacted my office this morning. She was having some car trouble and expects to be here around 9:30 or so.
Mr. Barshaw, if you can come forward, please. We'll go on the record in People versus Andrew Barshaw, case number 256830. The record should reflect Mr. Barshaw is present here in the courtroom. Like, counsel, put your appearances on.
The record, Your Honor, I tell the people.
Thank you, Your Honor. Richard Truce, appearing on behalf of Mr. Barshaw.
All right. Mr. Truce, how do we want to proceed in this file?
I thank you, Your Honor. This is our first hearing up in the circuit court here. I've had some discussions with the prosecutor about an offer. I think it's one that we're likely going to take. We're just not there yet. I was able to confirm the offer with the prosecutor this past Friday, had some preliminary discussions with Mr. Barshaw. We'd like some time, though, to be able to score it out so we know exactly what we're looking at, as well as I think he's got some arrangements he'd like to make. And frankly, Your Honor, it's mostly on my schedule, as the court's probably aware. I've had a complicated and busy schedule the last month or so. So I would suggest to the court 60 days, I think, would be more than enough time for us to get everything in order.
All right, Mr. Roloff.
This court's well aware, as Mr. Truce just indicated, both our dance cards have been rather full lately. I think this is the first time in circuit that we have no objection here.
All right, Mr. Barshaw, have you talked to Mr. Truce about this delay in proceedings? Do you have any objection to that? Sir. Okay. All right, so the court will set this for a plea hearing status conference in 60 days. At that time, Mr. Barshaw will need you to have made a decision about whether you want to enter into any kind of plea agreement. If you decide not to on that date, then we'll set the matter for trial. Okay. Anything else we can address here today?
No, Your Honor.
Mayor, thank you.
Okay, thank you. That's all.
I would suggest to the court, Mr. Knudsen is lodged. If the court did want to address his matter early, I don't know if there's any reason.
Okay, so and we need to have Mr. Haas brought up or something.
Yes, Your Honor, they're getting them ready right now.
Okay, great. All right, let's take a short recess and then we'll proceed with Mr. Haas's case and then we'll see where we go.
All rise, please.
Go on the record now in People versus Joey Michael Haas, file number 246776, 6779, and 6780. The record should reflect that Mr. Haas is present here in the courtroom today. This is the date and time set for sentencing. Mr. Haas, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, Rob.
Mr. Trush, are there any additions, deletions, or corrections that need to be made to that report?
Yes, Your Honor, we do have just a few. So on CFJ 284A, under the section evaluation and plan, it indicates that Joey, before the court for sentencing is Joey Michael Haas, a 40-year-old single male. He's 42. I think it was just because they did an update and kind of pulled and pasted out of that.
Okay, make that correction.
And then same page down at the bottom under additional information, it says the offender has 3 stalking personal protection orders. I'd ask the word stalking be removed. I mean, there's no question he has some personal protection orders against him. I think the bases for those vary in terms of the underlying facts.
Judge, that's of course well where you only get personal protection orders for 2 reasons now. One of those is stalking and one of those is not. So I don't know that that's incorrect. I mean, I live to the court, whether you want to leave that or makes a difference.
I don't know that it's incorrect either. I do think though that there's a variety of reasons why those orders have been entered. Stalking, but other conduct as well. So I think ultimately it's probably more accurate just to indicate that there are personal protection orders. So I'll have that stricken. Mr. Church.
That is all the corrections that we had.
Are there any objections to the guidelines as scored?
No, Your Honor.
Mr. Gola, did the people have any additions, deletions, or corrections?
No, Your Honor.
Do you have any challenges to the guidelines?
No, Your Honor.
Do you have any victims that wish to address the board? Anything on behalf of the people for allegation?
Yes, thank you. These are the defendants 11 and 12 felonies which were committed on November 7th, 2024, while the defendant was on parole. Coming parole in March 2024. We had a situation with the UDAA in file 246779 FH, which in this particular case, we have effectively vehicles being stolen to allow the defendant to be able to get to the location where he committed the other offenses. In light of the fact that this defendant, while dressed in black, stole 2 vehicles to get to the victim's residence, this was clearly a planned out action. It was not a spur of the moment decision. The defendant presents a continued threat to society. He's not incarcerated. The court specifically has to take that into consideration in sentencing. Thank you.
Thank you, Mr. Trush.
Your Honor, I take a slightly different view of the circumstances here. I don't know that there's anything to suggest out that this was some maliciously planned event. What I would point to the court here is this isn't a violent offense. When you get to the core of even the stalking portion of it, he showed up at the house, he dropped something off in a car, and he left. He didn't take any sort of actions to try to enter the house. He really didn't even have any interactions with the people there, other than they saw him there and called the police. It really is a nonviolent event. Mr. Haas indicates to me when he did parole, he sort of threw himself into work and, was working, 12 plus hour days every day and was really just trying to stay out of trouble. As I look at this scenario, it draws my attention sort of to the new expungement statutes and specifically like the one bad night situation. I think he was trying to do the right things and was, kind of throwing himself into work. I don't have a good explanation for how this happened, but I think it is sufficient to say it was a bad night. I don't think he, I don't think he, in his rational state of mind, would take the actions that he would here. I think the recommendation here is consistent with what the agreement was, which is to stay within the guidelines. And I think that makes sense through the lens of because he has the parole detainer, he doesn't have any credit. So whatever the court issues as a sanction, necessarily that parole sanction is going to be consecutive to it. So necessarily, I mean, he's looking at a significant sentence, even under the agreement. So I would ask court to follow the recommendations.
Thank you. Mr. Haas, anything that you wanted to say?
All right, I read through the report. I'm familiar with the circumstances in this particular case. I'm familiar with your history and background, Mr. Haas, through the information in that report and in prior cases that you've been in front of me on, both criminal cases as well as the personal protection order cases involving protected individuals that we identified earlier here. So I'm well versed in kind of all the circumstances here from a global standpoint. I do think that number one, the court's going to abide by the agreement and stay within the guidelines. I kind of disagree with both counsel in terms of some different aspects of what they stated. I don't think this was a planned thing. I think you have a history of doing okay, you know, flashes of staying on the right path, and then you go off the rails. And that's been kind of a repeated pattern throughout the course of your adult life. So I don't think this was a planned thing. I think that's a distinction without a difference because it doesn't really make it any better. Your behavior was erratic, unusual, I'm sure very frightening to the individuals involved, especially considering that they've had past experiences with you that would make the mere sight of you make them concerned for their safety. And so whether or not there was any assaultive behavior, or whether you were trying to actually make contact here, I don't think matters from the standpoint of victims, given the history, given that there were personal protection orders in place, and given your just erratic behavior during the course of this incident. So that, in addition to your past history, provides the court, I think, the basis to sentence you to a Michigan Department of Corrections sanction that is within the guidelines. You've been on probation 5 times, you've got 11 prior jail sentences. I don't see anything to be gained by probation or a community sanction in this case. So the court is going to follow the recommendation to the extent that as to file number 246776, court is going to sentence you to 28 months to 7 years, 6 months in the Michigan Department of Corrections, as indicated. Due to your parole status, there is no jail credit. Court is going to order restitution in the amount of $490 on that file payable to the Otsego County Clerk to be dispersed to Dustin Miller. Crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state cost. As to file number 246780, that's the aggravated stalking. Again, 28 months to 28 months to 7 years, 6 months. Credit for 0 days served, the crime victims assessment of $130 and $68 state cost. You do have the ability to seek an appeal of each of these sentences. We're going to provide you with some paperwork which explains to you what your appellate rights are, as well as how to request a court appointment. Mr. Trush has Mr. Haas now assume that his appellate rights.
Yes, we went over them directly before the hearing and they've been tendered to the clerk already.
Mr. Haas, you are remanded to the custody of the state. Is Ms. Albright? People versus Albright, file number 256828. Record should reflect Ms. Albright present in the courtroom today. Mr. Trush, how does you want to proceed in this file?
Thank you, Your Honor. This is our first hearing up here before Your Honor after the bind over. We are in receipt of an offer from the prosecutor. The offer would be to plead to count 1 and dismiss the rest of the complaint. So that is to say the enhancements. Similar to the earlier case today, I was able to confirm that offer with the prosecutor's office on Friday. I've had some discussions with Ms. Albright, but we're not quite there yet. I do think ultimately that we're going to accept that offer, but there's still some discussions we need to have. In this case, I would ask for 30 days. I think that would be sufficient time for us to get where we need to go.
Objection.
Ms. Albright, have you talked to Mr. Trush about delaying this for a month? Any objections to that? So we'll set this for a status conference plea hearing in about 30 days. Ms. Albright will be notified of the date and time of that hearing. It's important that you're on time for that hearing, so whatever you need to do with regard to vehicles and so forth, make sure that your plans are here early or on time. Okay.
Yes.
Thank you. That's all for today.
Our next hearing set for 9:45, People versus Lundy will be in recess until that time.
Oh, I'm sorry.
Yeah, that'd be great. Thank you. Mr. Knudsen, we're just getting your attorney here in the courtroom. Just 1 minute.
No problem.
Mr. Trush, we have Mr. Knudsen on video, so we'll go on the record and People versus Adam Knudsen, file number 256800, 6801, and 6822. Mr. Trush, can you tell me how you want to proceed with these files today?
Yes, Your Honor, thank you. Richard Church, appearing on behalf of Mr. Knudsen. Your Honor, just to give the court a little bit of the background in regards to these files, I think Mr. Baber was the original attorney of record. My understanding is they had got to the point where they thought that there was a negotiated agreement. Ultimately, that kind of fell through. In the wake of that, there was a breakdown of the attorney-client relationship there. Mr. Baber withdrew and I came into the case. I've only been in the case for a fairly short period of time, I think about 30 or so days. I have had some good discussions with Mr. Knudsen as far as what we're trying to achieve, and some good discussions with Ms. Brooker as far as what an offer would look like. I think we're closer than we are further apart. I would ask the court for 30 days to get this wrapped up. Again, I really think we're probably 85% of the way there. There's just a few spots we need to buff out.
Mr. Rolla?
I agree with what Mr. Church indicated. I'd also put it into the record that per discussions with parties with Ms. Brooker in our office, the amended plea offer was indicated and provided to the defense on May 5th, 2025. Thank you.
Okay. Mr. Knudsen, were you able to hear what the attorney said?
I could hear Counselor Trush. I could not hear the prosecutor.
Okay, the prosecutor just indicated that he's not objecting to an adjournment and indicated that he had communicated a new plea offer to your attorney 2 days ago on May 5th.
That is correct.
Okay, Mr. Knudsen, you understand that by delaying this another 30 days, that if this were to go to trial, that could result in a delay in your ability to have a timely trial in this case?
Yes, Your Honor, I do understand.
Okay, with that in mind, do you have any objection to adjourning as your attorney has suggested?
No, Your Honor.
Okay, so I'll set this for a plea hearing status conference in about 30 days. And we'll go forward at that time. Mr. Roll, anything further on this file today?
No, Your Honor, thank you.
Mr. Church?
No, Your Honor.
Mr. Knudsen, do you have any questions?
No, Your Honor.
Okay, all right, thank you. That's all for this hearing today, and the court's going to disconnect at this time. Mr. Church, do you need a minute to speak with Mr. Lundy?
I do not, Your Honor. We had an opportunity to discuss this outside before I came back in.
Mr. Lundy, if you'll come forward, please. Protocol People versus Tristan Lundy, file number 236668. The record should reflect that Mr. Lundy is present here in the courtroom today. This is the date and time set for a sentencing hearing on probation violation. Mr. Lundy, have you had an opportunity to go through the violation report with your attorney and speak about that?
Yes, Your Honor.
Mr. Trush, are there any corrections that need to be made to that report?
No corrections, Your Honor.
Mr. Rowland, do people have any corrections? Anything on behalf of the people with regard to allocution?
That's the PV judge, and I think the basis for the recommendations contained. The interesting thing I found out about is the reference to the fact that, as indicated, it was fortunate that Prosecutor County elected not to authorize new criminal charges for his failure to comply with the Sex Offender Registration Act, heavily under these circumstances. The fact the matter, though, is in light of the defendant's history as indicated, continued probation is just going to set them up for more failures. I don't think that's a realistic solution. I think some form of incarceration is appropriate. Thank you.
Thank you, Your Honor. I disagree with that assessment on a few different levels here. So, I mean, we start with, this is really Mr. Lundy's first, I'll say, substantial interaction with law enforcement. I do think he had a few minor issues prior to this, but I mean, this is his first real interaction with the police. And it's significant. I mean, it certainly is not an insignificant thing. Mr. Lundy is a young man. We're dealing with a first probation violation, and we're dealing with a circumstance which I certainly am not going to suggest is not a violation, because it is, but it's a circumstance I think that is understandable and really highlights why continued probation I think is important here. We have a person who's very young. Frankly, he's learning how to be an adult still. We have a situation where the violations here are based on essentially, there's 4 violations, 3 of which are dismissed, but they're based on the same core act, which is he didn't update his address as required by probation and required by SORA. And the prosecutor is accurate. I mean, he certainly could have been charged with a crime for that. Antrim elected not to do so, and I certainly can understand why they would, given he's being violated here. The underlying facts and circumstances of that situation, though, are that his grandparents kicked him out of the house. And I don't know why they did that, but I'm certain they had their reasons, and probably good reasons for doing it. To me, though, this highlights exactly why continued probation is good. He's a young man who's learning to be an adult. He's learning to take care of the responsibilities that come with that. And he has enhanced responsibilities because of the conduct here, the underlying conduct, and the responsibilities that SORA are placing on him. I think that's critical because the continued supervision is going to help him learn to do those things. So to discharge him on his first real attempt at probation, on his first violation, under circumstances that, again, I don't want to downplay, but are understandable. He, in January of one of the worst winters that we've had up here, gets expelled from his house. And his first thought isn't, oh, I've got to go and update my probation agent and update SORA. His first thought is, I have to find a place I can stay. Again, I'm not going to say it's the right reaction to this, but it's understandable. I would like to see him continue on probation because I'd like to see him set up for success in the future. If we discharge him now and there's no supports there, what I see in the future is he's going to continue to struggle with the obligations that he has because there's not going to be any support there to help him to lay the base for that. If he continues with probation, I think the probation department and Mr. DeLeo can help him to understand how to manage some of those obligations. And I really think, the original report, and this is referenced in the evaluation and plan from Mr. DeLeo, and frankly, this is one of the rare cases where I sat in on the PSI interview process and participated in that with my client. And I think it's accurate to what Mr. DeLeo expressed at that time. The writer indicates probationer's at a crossroads in his life. Either he needs to make some serious changes or he's going to find himself in court again facing more severe consequences. That's absolutely accurate. Absolutely accurate. And I'd like to think that, probation is going to help him to meet those obligations he has to do. I think if we discharge him, what we're going to see is he's going to struggle to comply with SORA, and he's going to be back in front of your honor on various violations of SORA and ultimately wind up in MDOC. That doesn't have to happen. We can see in here that he's making efforts. I'm not going to say they're perfect. I mean, he was participating in the classes he had to do. Admittedly, he'll have to start that over because he missed 2 classes. He is employed. I mean, he's making progress. I just think it's premature to jump to discharge from probation. Thank you.
Thank you. Mr. Lundy, anything you wanted to say?
No, Your Honor.
All right. I read through the violation report. I read through the initial report from last April, been on probation for about a year, to refamiliarize myself with the underlying facts of your case and of course what's gone on since then. First of all, there's been issues on probation, as you're well aware. You haven't paid anything towards your fines and costs in a year. It's still the exact same balance. You've got this issue of not complying with the Sex Offender Registration Act. There's some indications in here that you've been continuing to associate underage girls, which is a violation of your probation that was not pursued, but could have been. You didn't complete those classes. You were absent twice. You got kicked out after about half, maybe a little more than half of those classes. So there certainly have been issues with your compliance on probation, which tells me that you're not taking it seriously. And I agree with Mr. Trush to the extent that I think discharging you from probation now is kind of letting you off the hook. And I'm not ready to do that. And I think there needs to be supervision of you because of what you did in the underlying case and because you're continuing to associate with females that are underage. So I think letting you off probation and just having you search in jail and then cutting you loose to do whatever you want to do is the wrong decision at this point. I think the proper thing here is to continue you on probation so that there's some oversight of you and what you're doing. So that if you don't do what you're supposed to do, there's going to be a consequence there. I think you need to do some extra jail time now as well, because the first 99 days didn't sink in. I'm going to sentence you to an additional 90 days today. Hopefully that will make more of an impact on you. If you violate your probation again, I've got at least about 6 more months that I can impose. So it's really up to you if you want to keep coming back here and spending more time in jail, or whether you want to comply with your probation and do things the right way. And that goes back to that original statement that Mr. Trush referenced. It's your time to decide at 21 years old or 22 years old where you're going to go with your life. And it's either going to be the route of jail time, continued court involvement, or it's going to be the route of getting yourself on track, behaving like an adult. So the court finds that an appropriate sentence for the reasons I stated is to continue you on probation. The court is going to sentence you to an additional 90 days in the Otsego County Jail. Once that's completed, that would give you a total of 189 days of credit. As I stated, you've already served 99 days. And the court is going to, as I said, continue you on probation under all the same terms and conditions. You do have the ability to seek an appeal of the sentence. And Mr. Trush, can you have Mr. Lundy acknowledge that?
Your Honor, in regard to the sentence, would the court consider work camp after any period of time?
No, I think Mr. Lundy needs to sit for 90 days and let this sink in. Correct, he had 99 before.
Tendering the acknowledged rights to the court.
Our next hearing set for 10 o'clock. We'll go off the record. Mr. Matthew, are you able to hear me okay?
Yes.
Okay. And Ms. Calgara, are you able to hear me?
Yes, good morning, Your Honor.
Good morning. We'll go on the record now in People versus Matthew, file number 205947. The record should reflect that Mr. Matthew is present today by video from Department of Corrections. We have both counsel connected. This is set for a status conference in this file today. This is a file that has been pending. We had a resolution of a different file by jury trial recently. And so Ms. Calgara, you had a chance to speak with Mr. Matthew about this file?
I have not, Your Honor.
What's that?
I have not.
You have not, okay. Have you attempted to do that? Is it a Department of Corrections issue or what's been the problem?
Yeah, I did. I've tried several times, and it's either been like I've caught at bad times. There was also the time of transfer where I couldn't speak to my client. I apologize for that delay.
All right. Mr. Rolla, has there been a plea offer in this file?
There is, judges, the court's well aware the defendants have been charged with 8 counts of criminal sexual conduct in the first degree and a 9th count of criminal sexual conduct in the second degree. He's also charged as a habitual offender second offense notice. There's a plea offer that can plead to 2 counts of CSC first degree for dismissal of the remaining other 8 counts, as well as the habitual offender second degree.
Ms. Calgara, were you able to hear that?
Yes, Your Honor. This has been a previously communicated an offer.
Okay, I just want to make sure it's not different or the offer has changed.
No, my understanding has not.
All right, so obviously, Ms. Calgara, I mean, do you want to, first of all, I can connect you in a breakout room with Mr. Matthew today so that you can have a discussion with him. But did you want to set this out until you can have more detailed discussions with him, or how did you want to proceed today?
No, Your Honor, I am almost sure that I know where my client's, almost positive that I know where my client stands. If you could put us in a breakout room for a couple of minutes, I don't think there's a need to set this out further.
Sure, okay. I will place you into a breakout room right now.
Thank you, Your Honor. Your Honor, if you're there, I'm not quite sure if Mr. Matthew can take himself out of the breakout room.
Okay, we have Mr. Matthew and Ms. Calgara back, so we're back on the record. Ms. Calgara, were you able to speak with Mr. Matthew in the breakout room?
I did, Your Honor, and at this time, Mr. Matthew is not interested in accepting the plea offer.
Okay, so we'll get this matter set on the calendar for trial. Mr. Rolla, how far out do we need to schedule the trial?
60 days.
Ms. Calgara, how much time do you need to be prepared to go to trial in this matter?
I have multiple trials through June, July. I'll be in person the big first part of the month for a mediation in federal court in Tampa. August realistically is the most flexibility I have over the summer months. Though I recognize due to how this case is, if the court needs me to be more flexible. But June and July are looking a little rough.
Okay, so if we set it 90 days out at least, that's enough time for you to be prepared.
Yes, Your Honor, thank you.
Mr. Rolla, how many days of trial do you need?
I only see 9 witnesses, so probably 3 days, Judge, including whatever case the defense issue.
Ms. Calgara, Mr. Rolla is suggesting 3 days for the trial. What are your thoughts on that?
Your Honor, I would say anywhere between 3 and 4 would be reasonable.
All right, I think I'm gonna set it for 4 days just in case it takes extra time to pick a jury. Set it for a 4-day jury trial, no sooner than 90 days. I will, as the court typically does with scheduling, set it for a final status conference on the motion day immediately prior to the trial date. So the court will send out a notice of the date and time of that final status conference hearing as well as the trial dates. Final status conference will be the cutoff date for any pleas, and then will also be the motion cutoff date. So both sides are free to file motions at any time, but they must be filed and heard no later than the date of the final status conference. Any other dates that I can address for your side?
I don't believe so. Thank you.
Ms. Calgara, are there any other dates that I can address for your side today?
No, Your Honor, thank you.
Mr. Matthew, do you have any questions about how we're going to proceed?
I do not, Your Honor.
Okay, thank you. That's all for this hearing today. Again, the court will send out those dates. All parties are free to disconnect at this time.
Thank you, Your Honor.
All right, thank you, Your Honor. Thank you, Fabiola.
Absolutely.
All right, our next matter is People versus Key. Take a short recess and back on the record in that case.
Said he's going to report me to the State Bar of Michigan. I have no interest. I think it's contrary to his best interest for me to continue with this sentencing today, since he has such issues with my professional conduct currently.
All right, Mr. Key, do you want to make a statement regarding that?
Yeah, I brought up a rule and then he said he wants to resign, so then I said, no,
Okay, tell me that again.
I brought up a rule, like one of the rules in the code of conduct for lawyers. And I brought up one of the rules and the.
What rule did you bring in?
Rule 1.4.
What's that one?
The duty and candor to client.
And then, well, he said he's going to withdraw. So I said, well, so then I can no longer put in part.
Okay, outside of this issue, Mr. Clayune, have you gone through the PSI with Mr. Key?
I have.
So, Mr. Key, what I think is going on here, there's been a lot of delays in your sentencing. I think you're just trying to put this off. We were here last time, said you didn't have enough time to go through the PSI, so I played it then. You didn't appear for sentencing, I believe, right? Did we have failure to appear in the bench warrant?
Yeah, there was order revoking bond. Yeah, 3-5, defendant is not present, was revoked.
So this was originally set for sentencing on March 5th.
Looks like it, yeah.
Judge, according to my records, we had sentencing of March 5th, 2025. That's when sentencing was going to continue to April 9th, 2025, and then adjourned again because at the defense request warrant to review the PSIR, and now we're here.
Okay. Yeah, so what that looks like to me, Mr. Key, is a deliberate pattern of conduct on your part to delay your ultimate sentence in this case. And I view this as just one more opportunity for you to delay this further. Sure.
Well, I just have not been able to get hold of him, or like I've not had much communication with my lawyer, and since then, and there's certain stuff like I asked him for the body cam footage, like a while, like the 18th, I asked him for body cam footage, and he said he sent it. He said he sent it to my mother, and she has not received it anywhere. And there's stuff with the case that I asked him for, and I have not received.
None of that would apply to sentencing. You've already been convicted. That part of challenging it is over with. You can challenge it on appeal if you want to appeal your conviction, but
if I take a plea, then I believe I'm not open to appeals. So that's why.
Then you shouldn't have taken the plea.
Well, I was not fully informed or adequately.
Well, that's something you can challenge on appeal as well.
I believe if I take a plea, then I will not be able to challenge it.
You've already taken a plea.
I don't. Which I was not fully informed when I took the plea.
Yeah, so you can challenge that on appeal. That's not a reason for me not to go forward with sentencing now. And again, I think you're just trying to play it. I think you're trying to come up with any reason you can to not go through with sentencing because you know you're facing a long prison sentence.
Well, I understand that. I understand why you think that, but on my time, at time in WC is better than time in jail. There's no reason.
I don't know whether that's true or not. All I can tell is based on the record that I'm looking at of what's gone on since you entered the plea. It's been delay after delay on your part, and I'm not going to delay this further. Mr. Clayune, I understand you've made the request to withdraw. In my view, and I've had this come up before where defendants file grievances against their attorney in an attempt to delay matters and to get new attorneys appointed and so forth. There's some pretty solid case law that you're filing a grievance doesn't disqualify an attorney from representing the client, particularly under circumstances as this, where I'm finding specifically that Mr. Key's trying to delay his case. So we've got your request on the record. I think that protects you in terms of your professional responsibility, and I'm going to order that we proceed.
That's fine. I just want to make it clear. I never had a problem with Mr. Key. until today, I didn't know we had an issue, but
Neither did I, and it's never been raised by Mr. Key prior to today, which again, is what I view as a delay tactic. So for the record, Mr. Clayton, I'm ordering that you continue your representation for the purposes of this hearing. And we're going to proceed with sentencing today. Mr. Clayton, are there any additions, deletions, or corrections that need to be made to the report?
no, sir.
Are there any challenges to the scoring guidelines?
Mr. Clerk, in my opinion.
Mr. Rolo, do the people have any additions, deletions, or corrections?
No, Your Honor,
Do the people have any challenges to the scoring?
I do not, the only, I don't know if truly corrections in this, but I believe that's an adjustment to this. As again, specific.
Okay, so the sentence date is on the PSI dated as March 5th. That's with 2 days of credit.
So from his arresting of the bench warrant, which was 3/20/25 to today's date, he's entitled to 50 days total.
Say that.
50 days total.
Okay,
Thanks, Judge.
thank you. Any challenges to the scoring? Anything by way of allocation? I think
Yes, I do. This is the defendant's fifth felony, third controlled substance felony. His dog record requires are number 3 and 4. For reasons which are not indicated in the defendant's PSI, this defendant received the Sheboygan County Drug Court Program on October 11, 2016, even though he was convicted of a sexual assault offense and crossing minors for moral purposes. That was number 2 of 9. And now faces sentencing for trafficking large amounts of methamphetamine in northern Michigan. Now, while I understand 55.5 grams of methamphetamine, which is almost 2 ounces, by the way, along with 10 fentanyl pills, might not seem to be a great amount in maybe Wayne County, Genesee County, Oakland, or even Macomb County. But for northern Michigan, Your Honor, I think the court can take notice that guidelines in this particular case are 78 to 130 months. MDOC sentence is appropriate, and no further delays in sending this defendant to prison should be granted by the court. Thank you, Your Honor.
Mr. Clayton.
Thank you, Your Honor. And noting the agent's evaluation plan in this case, it focuses entirely, in fact, it says verbatim, the only focus the court should have was regards to community safety, public safety. I think that's really missing the point. It's missing the opportunity with Mr. Key. He submitted letters to his family. He's told me in other conversations that he desires to get clean and be sober and live a law-abiding life. The letters of support from his family. I talked to his mother, his girlfriend. They all support him. You know, I understand the sentencing guidelines on a B grid are pretty significant. They are. But to simply say as part of an evaluation plan, they were simply just going to warehouse them so that public is safe. It doesn't solve the problem. It doesn't solve the problem 6 years from now, 5 years from now. The problem is not solved until Mr. Key gets the tools, and I'm sure he will get the tools, but he wants to focus on a rehabilitative sentence. So I would ask the court to not adopt the policy of community safety, but look at rehabilitation. I'm sure there's punishment, there's public safety concerns, there's deterrent messages to others, but the court could heavily focus with Mr. Key on a rehabilitative sentence and allow him to return to the community a better person than when he left.
Mr. Key, anything that you wanted to say?
Just Clayton said, I realize that I was, I'm not trying to get over any punishment. I just, I know I did wrong. I just want, part of the reason I was trying to, bring all this up is because I wanted to be able to treatment and rehab before I went to MDOC, which I'm not saying it's an option. I do want to be better. So.
All right, I did read through the report, so I'm familiar with what happened in this circumstance. I did receive letters on your behalf, one from Caitlin Sullivan. I had a chance to review that documentation. And I take all of that into consideration along with what the attorneys have had to say here today and yourself. What concerns me about this circumstance is the amount of drugs that you were bringing into this community. I think 55 grams is a lot. No matter where you're at, I agree with the prosecutor on that. Given what the day, the normal single dose is of methamphetamine, 55 grams is a massive amount of methamphetamine that you were bringing here to this community. And that's to say nothing of the fentanyl, which is a deadly substance and kills people the first time they use it without warning. And so the danger that you pose to this community in bringing those substances here warrants a serious punishment. And the law provides for serious punishments for that type of conduct because it is beyond merely possessing a personal use amount or even small amounts that you're selling here and there to fuel your own supply. This is way in excess of this and indicates a degree of trafficking, again, that in my view warrants a serious sentence in this case. You've had some prior interactions, you've been on probation 3 times as an adult, once as a juvenile. You've had 6 prior jail sentences and 1 prior prison sentence. So prior attempts at correction not been successful. I agree, looking at your history, that treatment is something that you need. Unfortunately, given your past history and the nature of this offense, with the minimum of guidelines at 78 months, doesn't give the court any options for community sanction. So to the extent that you're able to get treatment, you have to do that through the Department of Corrections or once you're released on parole. I do find that a sentence within the guidelines would be appropriate. It would accomplish the goals of punishment and deterrence. I don't find that there's any justification for going outside of the guidelines. But I do think a sentence within the guidelines is reasonable given the past history and the amount of drugs that we're bringing into this community during the course of this incident. The court finds that a sentence that would reasonably address your conduct. Again, the guidelines are 78 to 130 months. The court finds that a sentence of 120 months to 20 years is an appropriate sentence. So the court is going to sentence you to 120 months in Michigan Department of Corrections to 20 years. You do have credit for 50 days served. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, $68 state cost, fine of $1,000. You do have the ability to seek an appeal of the sentence, and Mr. Clayton, that you can provide appellate rights to Mr. B and McDonald to receive those appellate rights. You are admitted to the custody stages.
Thank you.
That I have a Crawford County case at 10:45, but I don't think we have anything left.
I believe that's the rest of the morning criminal document for Otsego County. We'll see you this afternoon.
All right, looks like everybody's getting connected here. And we have both counsel connected. So if I can have the attorneys unmute, please, and we'll go on the record. This is People versus Michael Marvin. This is Crawford County case number 245339. And if I can have both counsel put your appearances on, please.
James Sherman for defendant Michael Marvin.
Sierra Coke on behalf of the people.
All right, thank you. This is set today for purposes of an evidentiary hearing. There's been a motion filed by the defense to suppress evidence and to quash the search warrant in this case. We had a brief hearing. The court indicated that it would need to take some testimony in order to rule on the motion. So Ms. Koch, are the people ready to do that today?
We are, Your Honor.
Okay. Who is your first witness that you would like to call?
Your Honor, I'm going to call Deputy Taylor.
Okay. Deputy Taylor, are you able to hear me okay?
Yes, Your Honor.
Okay. Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Ms. Koch, whenever you're ready.
All right. Deputy Taylor, where are you?
The Crawford County Sheriff's Office. Sorry, it blurred out.
Yeah, Ms. Koch, you might have to, take a break between the answer and the question, because I think you're asking your question before the microphone has a chance to switch over to your voice. Now we're not able to hear you at all.
Can you hear me now?
Yes.
Okay. Sorry, we just got new computer systems in here. Deputy Taylor, how long have you worked at the Crawford County Sheriff's Department?
Over 7 years.
Okay. Were you working on August 8th, 2024?
Yes, I was.
On that date, did you do an affidavit and search warrant?
Yes, I did.
And did you do that as to Michael Marvin for his blood?
Yes, I did.
Did you do an OWI investigation on that same day as to Mr. Marvin?
Yes, I did.
Where did you do that search warrant at?
The search warrant, when I filled it out, was at the Crawford County Sheriff's Office.
And where did you conduct the OWI investigation?
In the parking lot of the Sheriff's Office.
Is the address to the Sheriff's Office 200 West Michigan Avenue, Greeley, Michigan 49738?
Yes, it is.
Did you conduct that investigation at approximately 1:09 p.m.?
Yes.
Okay. You wrote in your affidavit and search warrant that Mr. Michael Marvin drove to the Sheriff's Office. Do you believe that to be accurate?
Yes, it is.
Why did you believe that to be accurate?
Upon our investigation and Detective Capadlo's investigation, it was determined that Mr. Michael Marvin drove his vehicle to the sheriff's office on that date, and he was the sole occupant of the vehicle.
You indicate in your affidavit and search warrant that you smelled the odor of intoxicants. Is that correct?
Yes, I did.
Okay. You indicate Mr. Marvin was being disorderly. Did you observe that yourself?
Yes, I did.
Can you tell me how he was being disorderly?
Yes, when he came to the sheriff's office and I happened to be in the office with our administrative assistant, he began acting belligerent and demanding information from her. And he was so belligerent, it had upset her to the point where she was crying.
Have you ever seen this occur in the sheriff's department before?
I've seen people come into the lobby and be disorderly, yes.
Okay. Now, you indicated in your affidavit and search warrant that Mr. Michael admitted to drinking earlier in the day. Is that true?
Yes, he did make a statement of drinking earlier in the day.
Okay. You observed that you believed that you personally observed the above named driver to be under the influence of alcohol. Do you believe that's accurate?
Yes.
Okay. You indicated that you smelled the odor of intoxicant is moderate. Above, you had said strongly. Do you believe those to be accurate statements?
Yes.
You described his eyes to be watery, bloodshot, and glassy in the affidavit. Was that accurate?
Yes.
You described his face as being flushed. Was that an accurate statement?
Yes.
You discussed his balance. You described his balance as swaying. Do you think that's accurate?
Yes.
You stated you thought his speech seemed confused. Was that accurate?
Yes.
You offered him a PBT and he refused. Is that correct?
Yes, that is correct.
You gave him the standardized field sobriety test. Is that correct?
Yes.
How many clues are there in HGN?
6.
And how many did you observe with Mr. Marvin?
All 6 clues.
Which test is most accurate in the SFSTs?
The horizontal gaze nystagmus.
Did you also give him the one-leg stand test?
Yes, I did.
And how many clues did you see in the one-leg stand?
In the affidavit, I wrote 1. Upon reviewing my body camera while I was typing the report, I observed 2.
Now, you prepared this affidavit and search warrant and provided it to Angie Craig. Who is that?
She is the magistrate.
Is everything that you put in the affidavit accurate?
Yes.
Okay. Did you rely on that? Did she sign a search warrant?
Yes, she did.
Okay. And what was the search warrant for?
Mr. Marvin's blood.
Did you rely on that search warrant in taking him to the hospital?
Well, he was already taken up to the hospital because he originally consented to the blood draw. And then when he got to the hospital, he changed his mind and he stayed at the hospital while I conducted the search warrant.
Okay. And where were you when you got the search warrant back that was signed by Magistrate Craig?
In her office.
Did you rely on that signed search warrant when attempting to have the blood drawn from Mr. Marvin?
Yes.
Was the phlebotomist ultimately able to obtain that blood?
Yes, he was.
And have you gotten the blood alcohol results?
Yes, I have.
Okay. And what were those blood alcohol results?
0.181.
Do you believe that there's anything in your affidavit and search warrant that was false?
No.
Do you think that there was anything in there that was a disregard for the truth?
No.
Were you the one who personally conducted the SFSTs on Mr. Marvin at the Crawford County Sheriff's Department that day?
Yes, I was.
How did you come in contact with Mr. Marvin? Did you have a traffic stop?
No. Mr. Marvin came to the sheriff's office.
Was he asked to come to the sheriff's office or did he come voluntarily?
I don't know. I believe it was voluntary.
Did you observe a video of Mr. Marvin driving a vehicle that day into the sheriff's office?
Yes.
Do you know how long? Did he stay in his car for any period of time?
I believe from the time he parked to the time he walked into the sheriff's office was about 3 minutes.
Okay. And you observed that yourself on the recording?
Yes, I observed it in Detective Capado's office.
All right. Was the sole reason for obtaining the search warrant for his blood alcohol related to the refusal for PBT or the totality of the circumstances?
The totality of the circumstances.
Do you recall how much Mr. Marvin had indicated to you that he had drank that day?
I believe he stated he had 2 or 3 light beers earlier in the day.
Based on your training and experience, is that a sufficient amount of alcohol to get somebody to a 0.181?
No.
Do you know how long there was between the time that you had contact with Mr. Marvin and gave him the SFSTs to the time that his blood was drawn at the hospital?
I believe it was around 90 minutes.
Did you do a search on his vehicle?
Yes, I did.
When did you do that search on his vehicle?
I'd have to refer to my report for the time.
What was it, before or after you had his blood drawn?
It was afterwards.
And why did you do a search of his vehicle?
Based on probable cause of my investigation and also our policy for inventory vehicle searches at the sheriff's office.
What were you going to have done, or what did you have done to that vehicle that day?
I searched it and photographed it.
And then what happened afterwards to that vehicle?
I believe we left the vehicle there. We didn't tow it or anything.
What did you find in the vehicle?
In the vehicle, I located several empty beer cans and like tops to other beer cans, like for glass bottles. And I also observed a partially drank beer bottle that was behind the center console in the cup holder.
And Mr. Marvin was the sole occupant of that vehicle prior to him exiting it at the sheriff's office?
Yes, besides his dog. He had his dog with him.
Okay. I have no further questions for Deputy Taylor.
All right, thank you. Mr. Sherbin, do you have any questions for Deputy Taylor?
Yes.
Thank you, Your Honor. Yes, I do have questions for Deputy Taylor.
Okay, proceed.
Good morning, Deputy Taylor.
Good morning, sir.
So you testified that you observed Mr. Marvin's slurred speech.
I believe I said confused.
So his speech wasn't slurred. It was confused, right?
That's what I put in the search warrant.
You also testified you observed Mr. Marvin's bloodshot eyes on the day we're talking about, August 8th.
Yes.
2024. And when was that? In the course of your investigation?
It was when I was instructed to perform SFSTs on Mr. Marvin. As part of the HGN, as I do an eye check, I looked at his eyes and I observed his eyes to be red, watery, bloodshot, glassy.
So you just said this was after you were instructed to do, what is it again? I'm sorry, I'm not that great with acronyms.
Standardized field sobriety tasks.
And you were instructed to do those, correct?
Yes.
Who you were instructed to do those by?
Detective John Capadlo.
And he's higher in rank than you are, correct?
Absolutely.
So you have to do what he says, right?
Yes.
And the only reason you began the operating while intoxicated investigation is because he instructed you to do so, right?
Yes.
You didn't observe any confused speech or bloodshot eyes or any indication of that Mr. Marvin was intoxicated before you were instructed to start your standard field sobriety test, right?
Correct. I did not have face-to-face contact or speak to him until after Detective Capadlo spoke with him, and he stated he had a strong odor of consumed intoxicants.
So for all you know, the investigation that you began was unwarranted, right?
No.
But you didn't start the investigation because of any signs from Mr. Marvin, right?
Based on what Detective Capadlo observed, and as we stated, he is higher in rank than me, he instructed me to do the test because he observed signs of intoxications.
So you personally had no you had no personal knowledge of any signs of intoxication before you began your investigation into whether he was operating while intoxicated, right?
Yes.
Now, when you're going through the field sobriety tests with Mr. Marvin, you just testified earlier that he completely failed the horizontal gaze nystagmus test. Is that how you say it, right?
Nystagmus, yes.
He had 6 out of 6 cues for that, right?
Yes.
And you testified that that's the most accurate test that you have for what?
Yes.
So what is the test most accurate for detecting or giving signs of?
So with the horizontal gaze nystagmus, it's the most scientifically accurate test. If a subject shows 6 out of 6 clues, I believe there's a 88% chance that he is above a 0.08.
But there's other factors that could contribute to cues on that test, correct?
I don't understand the question.
So in your test, you're looking for you're using that test to look for cues as signs of intoxication, potential signs of intoxication, meaning over 0.08 blood alcohol content, right?
Yes.
So that cue that you look for, that could be triggered by factors other than consuming alcohol.
No.
So lighting could not affect cues on the test.
Correct.
Allergies could not affect cues on the test.
No.
Prescription medications couldn't affect cues on the test.
Not that I'm aware of.
Nervousness, could that affect?
Nope.
But you were doing the tests outside, right?
Yes.
And it was summertime, right? It was August, correct?
Yes.
And the sun was shining, right?
Yes.
You weren't under any shade, were you?
Where we were at, there is a section of that area that is shaded from the building. I don't know if it was shaded at that exact moment in time without reviewing the video.
So how many more tests are there when you go through your field sobriety?
Your Honor, I'm going to object. This is an affidavit to suppress the search warrant. So all we're going through is the 4 corners of the search warrant. We're not going through the SFSTs or any of that. It's very specific as to what the law requires, and it requires to look at the four corners of the affidavit of the search warrant.
All right, so Mr. Shervin, your motion it challenges that there was no probable cause for the arrest and that the court should suppress the blood test because there wasn't cause to issue a search warrant, as well as the search of the vehicle. So the hearing today isn't to prove or disprove whether your client was actually intoxicated. The court's inquiry here, based on your motion, is whether there was probable cause. So how does your last question go to that?
Your Honor, as you stated, my client's motion is asking the court to suppress evidence obtained as a result of a improper detention leading to an illegal arrest. So I'm asking questions to Deputy Taylor to elicit his testimony to see whether he had probable cause to make the arrest that he did. And I believe he goes through those standard field sobriety tests to determine whether or not he has that probable cause or not, among other things.
Okay, all right, I'll allow the question, go ahead.
So Deputy Taylor, what other field sobriety tests do you go through?
There are 3 standardized field sobriety tests. It's the horizontal gaze nystagmus, which we're checking the eyes. There is the walk and turn, which is a divided attention task. And then there's a one-legged stand, which is also a divided attention task.
And how did you do on the walk? How did Mr. Marvin do on the walk and turn on August 8th, 2024, when this incident occurred?
Oh, he did very well.
And what did you think about that, considering that he hit 6 of 6 clues on the horizontal gaze mistake?
Yes. So based on my training experience, serious alcoholics, they can tend to do very well on the physical tasks, but where they can't lie, it involves their eyes. So that's why the HGN is more scientifically accurate, because an experienced drunk can do very well on the walk and turn and the one-legged stand.
But you had no, you were given no indication that he was a, how do you put it, functioning alcoholic, correct?
I didn't know him, no.
And you still don't know him now, right?
No, I don't hang out with him.
So the remaining test, the one-legged stand, that probably wasn't too accurate, was it?
Well, he showed 2 out of the 4 possible clues.
You think maybe that's because of the tests he just went through? I mean, didn't he let you know he had medical conditions that may affect his ability to do the test correctly?
So yeah, he did make a statement that he had like a metal thing in his leg, but he said he had said, if you're not comfortable doing it, it's not something we have to do. And he said he would do it, and he did it, and displayed 2 out of 4 clues for intoxication.
So you say it's not something that you had to do for your overall investigation, you mean? Or
No, that was poorly worded. My apologies. So because he made that statement, I was like, are you comfortable doing this test? And he said he would be comfortable attempting it.
But knowing that, I mean, the cues that he exhibited during your test may not have been accurate, knowing what he just told you before that, right?
Well, I don't know that to be true. People lie to us all the time.
But you weren't going to make him do the test, right?
I don't understand.
You weren't going to make Mr. Marvin do the one-legged stand if he didn't want to because he had a metal plate in his leg, according to what he said to you. Right?
Yes.
So the results of that specific test really aren't too determinative of your overall investigation as to whether he was or whether he was not operating while intoxicated, right?
What's the question?
There's several tests you go through in your standard field sobriety, correct?
Yes.
Test. One of them is the one-legged stand, right?
Yes.
In this case, you weren't going to make Mr. Marvin do the one-legged stand because of what he had just told you about his leg, right?
Yes, and he chose to do it.
And so knowing that, the cues you saw on that specific one-legged stand test would not be determinative in your investigation. It would not cause you to conclude that he was or was not for sure operating while intoxicated. Not concluding that he was, but that you had enough to arrest Mr. Marvin as you did.
Well, I'm going to disagree. I mean, just because he says he has a metal plate in his leg doesn't mean he does. And I can't attest to how that metal plate in his leg, if it does exist, how he would be able to perform on a test.
So you weren't going to make him do the one-legged stand, but you're going to hold the cues that he exhibited against him. Is that what you're saying?
Yes.
And on page 3 of the case report for this incident on August 8th, 2024, you reported that you requested consent for Mr. Marvin to do a PBT, right?
Yes, I asked him for consent for a PBT with his rights to refuse, and he refused.
And do you have to ask him to take one of those? You got to ask Mr. Marvin, and do you have to ask, someone in Mr. Marvin's situation for a PBT every time you conduct an operating while intoxicated investigation?
Yes, if I believe he is intoxicated by alcohol, and a PBT is a tool to help confirm my suspicion of alcohol intoxication.
So you only use it if you believe he is intoxicated? If you
Correct.
believe the suspect is?
That's the only thing the PBT is applicable for, is testing for intoxication.
But if you already suspected Mr. Marvin to be intoxicated, what would be the need for a PBT test?
It's a tool to confirm our suspicion of intoxication. That's all it is. It's a tool.
And how did you respond to Mr. Marvin's denial to consent to a PBT?
That's his right to refuse.
I asked how did you respond to his refusal? What did you do next?
I don't know what I said to him, but after that, he was placed under arrest.
You arrested him, right?
Yes.
Did the detective instruct you to do that as well?
Nope.
Was he there present?
He was. I don't know if he was standing outside with me the entire time, but I believe he was there.
Did you feel under pressure to place him under arrest, given that he was watching, the detective was watching your investigation that he prompted?
No, the arrest was based solely on my observations.
So actually on page 4 of your case report under the charges and citation section, you provide reasons for why you issued the citation. Correct?
I don't know what you're referring to.
The the report you draft up after the incident occurs.
Can I review it?
Page 4, but yes, if you have it available there in front of you.
Your Honor, I'm going to object. This motion is to quash a search warrant. The case law on this is very specific. There must be allegations of deliberate falsehood or reckless disregard for the truth, and it must be accompanied by an offer of proof. The court rules require that there's a review of the search warrant involving the determination of whether a reasonably cautious person would have concluded that there was a substantial basis for the finding of probable cause. The affidavit must be read in a common sense manner. And then it says that's People v. Russo. And then a reviewing court should give great deference to a magistrate's determination of probable cause for the issuance of the search warrant. We haven't talked about any of the statements in the search warrant at all, really. It's just a generalized discussion about the OWI when they're trying to say the affidavit should be, the search warrant should be set aside. We're way off of what we're supposed to be focusing on here, Your Honor.
All right, so I guess what I'm getting from Mr. Sherman here is that he's challenging whether there was probable cause for the arrest, and it was after the arrest that Deputy Taylor drafted the search warrant. So if they didn't have probable cause to arrest in the first place, then the search warrant wouldn't be valid, even if it was otherwise proper. So I'll allow the question. Go ahead, Mr. Sherman.
Deputy Taylor, do you have page 4 there in front of you?
Yes.
And does that refresh your recollection of what you reported?
What was the actual question?
So on page 4 of your case report, under the charges and citation section, you provide reasons for why you issued the citation, right?
Do I give explanation? Yes.
And that's the reasons for why you issued your citation, correct?
I apologize. I don't know what your question is.
So you see page 4 of your case report that you drafted, right?
Yes.
And then under the title charges citation.
Yes.
You provide reasons for why you issued your citations. Do you remember that?
It says, during my investigation, Michael refused a PBT upon my request. That's what it says. I just don't, I apologize. I just don't understand what question you're asking me.
They're just yes or no questions, whether you provided reasons for why you issued the citation and whether they're provided under your under the charges and citation section of page 4 of the case report that you drafted.
Yes, it says I charged him for a citation for OWI-2, and then I wrote that he also refused a PBT, physically resisted and obstructed myself and Sergeant Swope and I during the execution of the search warrant for his blood, and located an open container of alcohol which was inside his vehicle, which none of which I charged him with on the citation.
I have no further questions, Your Honor. Thank you, Deputy Taylor.
Thank you, sir.
Ms. Koch, any follow-up questions?
Very briefly, is refusal to submit to a PBT, is that something that's typically cited on a ticket?
So it's actually up to the discretion of the officer whether or not we want to charge them for refusing to take a PBT. In this case, I chose not to charge Mr. Marvin for that civil infraction.
And as part of this investigation, did you review Mr. Marvin's criminal history?
I don't know if I actually reviewed it. It's standard to get the criminal history and attach it and give it to your office, but I don't remember reviewing it.
Do you personally have any information whatsoever about why the incident that Mr. Marvin was trying to obtain information for when he was at the police department?
No, I had no idea.
And everything you put in the affidavit and search warrant to get the search warrant for blood, was that based on your own personal observations?
Yes.
No further questions. Thank you.
Thank you. Any more questions, Mr. Sherman?
Yes, Your Honor. Again, Deputy Taylor, Mr. Marvin refused the PBT, right?
Yes.
And you used the PBT to confirm your OWI investigation as to whether you have enough to do as you did and arrest someone like Mr. Marvin, correct?
Yes, it is a tool to confirm our suspicion of intoxication.
And since he denied consent to a PBT, there were no results from the PBT for you to look at, right?
Correct. Everything was based on my observations and my training experience investigating OWIs.
So you had no confirmation that you had enough to arrest Mr. Marvin based on the lack of results from the PBT, correct?
I had no results of the PBT, that is correct.
So you had no confirmation of your suspicions as a result of your investigation, right?
Well, it's kind of a trick question, but
I'm not trying to trick you. I just you previously testified that you confirm your OWI investigation with a PBT, whether or not you suspect that the person is intoxicated, right?
Yeah.
And Mr. Marvin did not give consent for this PBT, and so there were no results from the PBT for you to confirm your investigation with, right?
Yes, that is correct.
I have no further questions, Your Honor.
All right, thank you. Ms. Cope, do you have any other witnesses?
Yes, I have Detective Sergeant Copado, who is also in the process of getting a new computer, so he's going to testify for my office if the court will allow. I think he's having computer issues.
Okay, that's fine. Deputy Taylor, you're free to remain present, or you can disconnect. That's totally up to you, okay?
I'll stay. I'm on training, but it's lunchtime now, so I'll stay in case the court needs me.
All right, thank you. Deputy Padlo, or Detective Padlo, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. And Ms. Koch, I'll just ask that you have Deputy Padlo speak nice and loud. His voice is a little bit softer than yours on the microphone there.
Detective Copado, where are you employed?
At the Crawford County Sheriff's Office.
How long have you been employed there?
For over 17 years.
How many OWI investigations have you conducted?
Oh, multiple hundreds.
Would you say even maybe 1,000?
Probably close to 1,000, if not more.
On August 8th, 2024, did you come in contact with Mr. Michael Marvin?
Yes.
Where did you come in contact with him at?
At the Crawford County Sheriff's Office in the court, in our office lobby.
Why did you come in contact with him?
I was called by the administrative assistant, Melissa Hall, because Mr. Marvin was in the lobby and demanding some paperwork.
Why were you the one called?
I had a previous conversation with Mr. Marvin on the telephone several hours before that, first thing in the morning.
And during that phone call, was there anything that was concerning to you?
At the time, he kept wanting to demand some paperwork. I told him I had a busy day, that I would call him later in the day, and he was very upset when we were on the phone.
About what time did you first have personal face-to-face contact with him at the sheriff's office?
I can give you the exact time if I can look at my report really quick.
Your Honor, I asked that he be allowed to refresh his recollection with his report.
Yes.
I would say about 13:06 hours. I was called about 13:04, so 1:04. So within a matter of 2 minutes from that.
What did you personally observe with Mr. Marvin?
When I first came to the sheriff's office, I walked into the administrative assistant Melissa Hall's office, and I made contact with him through our window. And in the window, there's an open little slot where people could kind of talk through. At that time, the minute I started to talk to him, I could smell a strong odor of intoxicants coming through the open portion of the window. So therefore, I walked around and opened the lobby door to be able to be into the lobby with him. And at that point, when I started talking to him, I confirmed my suspicion that I could smell a very strong odor of intoxicants inside that lobby.
And did you notice anything about Mr. Marvin physically?
Yeah, at that time, I observed him to not only did I smell it in the lobby, but I could smell the odor of intoxicant coming off his person. He had slurred speech, bloodshot, glassy, watery eyes, and was using the wall to kind of hold himself up there for a minute.
Based on what you observed, what did you do next?
I began trying to talk to him. I asked him if he drove there. He then made a comment about he refused to answer any questions. I did try to ask him what he was there for. I then explained to him that I had talked to him earlier in the day and that I told him I had a busy day. I was in meetings. I would have called him later in the day. While talking to him and observing all of those, I then went back to my office and reviewed the security footage from the county building to see what he had driven in. At that time, I observed him exit a vehicle, Chevy pickup truck with a dog. I then back played it to find out when he pulled into the parking lot. I watched him drive from Norway Street in front of the courthouse into the county building parking lot, where he then parked into the parking space on the far northwest corner of the building parking lot, and then observed him and his dog exit the driver's side of the vehicle and then walk into our office.
How long was he in the vehicle once he parked the vehicle?
Once he had parked the vehicle, before he exited the vehicle, I think it was about 2.5 minutes.
Based on your observations, did you ask Deputy Taylor to do something?
Yeah, so once I observed the vehicle and him come out of the driver's side of the vehicle, I asked Deputy Taylor to walk out there first to confirm if there was anybody else in the vehicle, to make sure that there was nobody else in it. He then walked out, got the license plate, confirmed that there was no other occupants in the vehicle. While reviewing the video, I seen that there was nobody else that had exited the vehicle. He was the only one to exit. There was currently nobody else in it. So that confirmed that we knew that he had been driven into the parking lot. I talked to Mr. Marvin a few more moments after that, and at which point I then instructed Deputy Taylor to conduct an OWI investigation.
And why did you have him do it rather than do that investigation yourself?
I was in the middle of election meetings at the county building.
Okay. I have no further questions for Detective Clapadlo.
Thank you, Mr. Shervin.
Thank you, Your Honor. You just testified that on August 8th, 2024, when this incident occurred, you were having a busy day, right?
That is correct.
You were at an important meeting when you got this call from Miss Hull, correct?
Yeah, I was in the county building at a meeting, yes.
And you rushed out of that meeting, right? To get to where Mr. Marvin was at the administrative office?
Yes, to come over and see what was going on. That is correct.
And you had to get back to that meeting, right?
Eventually I did, yes.
And you had spoken to Mr. Marvin on the phone earlier that day, right?
Correct.
So at this point, you were probably pretty agitated, right?
Agitated at what?
The situation, the day, Mr. Marvin. Is that correct?
You mean, was I agitated at Mr. Marvin for being at the building?
No, I'm just saying, isn't it correct that given the busy day, the length of time you had spoken with Mr. Marvin earlier that day, and what you had to leave to deal with Mr. Marvin, again, agitated you, made you not happy?
I would disagree with you to an extent, but Mr. Marvin called in the office on multiple occasions, and then me finally talking to him and me telling him that I would be contacting him later, and then him arriving, it didn't make me like mad, if that's what you're saying.
Yeah, right, but you weren't thrilled to have to leave that important meeting to address Mr. Marvin's situation, right?
Your Honor, I'm going to object as to why any of this is relevant as to the probable cause factor, as to what the detective felt towards Mr. Marvin and his behavior.
Yeah, Mr. Sherman, what does the officer's state of mind have to do with whether there was probable cause in this case?
Well, it makes it more or less likely that a fact, the consequence in this matter is true or not, that being whether there was reasonable suspicion to detain Mr. Marvin longer than needed to dispel the suspicion that he was being disorderly or whatnot, to make matters escalate into a full-blown OWI investigation. So his state of mind that he was in a hurry maybe makes it more likely that he saw indications of intoxication that weren't really there. He just was really looking for them, given his length of experience in his position.
Well, if anything, having to start an investigation into whether or not Mr. Marvin was intoxicated would only delay the officer further. So I don't see how that would make him want to. If he felt pressure to get out of that situation so that he could go back to his meeting, I would think that would tend more to a finding that he didn't want to start an investigation, because that's only going to keep him away from his meeting even longer. So I don't find it to be relevant, and I'll sustain the objection.
You also testified your first conversation with Mr. Marvin was through a glass window, correct?
Correct.
And you testified that you smelled a strong odor at that point of intoxicants. Is that correct?
That is correct. There's a 4-inch by 8-inch opening to the window. So there's a 4 by 8-inch hole in the opening of the glass so people could communicate, slide papers through.
Could you describe the smell for me?
I wouldn't know how to do that. It's just an odor of intoxicants. I don't know what he would have been drinking.
So he could have been drinking anything, right?
Something that made me believe it was some sort of intoxicants. Correct.
And then that prompted you to step out into the lobby where he was, right?
That is correct.
And you smelled an even stronger odor of intoxicants. Is that correct?
That is correct. When I become closer to him in the open area with him, and then within a couple of feet from him, and then there is no window barrier between us to be able to confirm what I was smelling.
Did you confirm what you were smelling when you got out into the lobby with Mr. Marvin?
That's why I walked in the lobby, because I smelled him through the window. So then I walked into the lobby.
Right. Did you confirm as to what you thought you were smelling when you stepped out into the lobby?
The totality of the entire investigation confirmed what I smelled, that he was intoxicated.
Well, at that point, the investigation had not begun, right?
Right, but you asked me if I ever confirmed it, right?
Oh, I'm sorry. That was my mistake in asking the question. It's probably confusing. When you stepped out into the lobby after you spoke with Mr. Marvin through the glass, did that confirm your suspicion as to what you were smelling? The strong odor of intoxicants.
So yeah, once I smelled that and I began to continue to talk to him to try to figure out what was going on, that's when I advised Deputy Taylor to then conduct an OWI investigation. Then that's what he did. So then he conducted the investigation from those incidents leading up to it.
But up until that point, up until the point where you instructed Deputy Taylor to begin his investigation, you had just smelled a strong odor, correct?
Negative. No, that is not correct. I could smell a strong odor of intoxicants coming from him. He had slurred speech, bloodshot, glassy water eyes, and was a little unstable using the wall when he was in there, and a little bit belligerent, and then refused to ask questions. And then I confirmed that he had driven into the parking lot. I confirmed that he came out of the driver's side of the vehicle. And then that's when Deputy Taylor took over the actual OWI investigation.
You testified that he had bloodshot eyes, but it was the summertime, and correct. And
I was in the lobby with him where there was no sunlight.
well, it was daytime when this happened, right?
Correct.
And it was in the middle of this summertime in early August, right?
August 8th. That is correct.
And you got grass right outside the sheriff's office where you all were talking with one another, correct?
Correct.
And they mow probably every other week, right, at the sheriff's department. Is that correct? Not that you would know
exactly how often they mow, but yes.
Right. They mow the grass, right? But I mean, isn't it possible that maybe Mr. Marvin had allergies or he was tired?
No. The OWI investigation confirmed that he was intoxicated. The whole entire investigation confirmed that.
Well, we're talking about the what you observed to prompt the investigation, though, right?
That's why we do an investigation, correct? It rules that out.
Because you didn't do the investigation, correct?
Nope, Deputy Taylor took that over. If we would have ruled that it would have been allergies, then he would not have been arrested.
But you wouldn't make the determination as to whether he had allergies, right?
I wouldn't know if he had allergies if he did not come out that he was arrested for OWI, correct?
Just like you probably wouldn't know whether he consumed something intoxicating or he just smelled like something that was intoxicating, correct?
What's the question? I'm sorry.
How could you be sure that Mr. Marvin consumed what it was you were smelling?
That the entire investigation led up to it. That's where the blood draw comes in effect to confirm that he was a 0.18, I believe it said.
But you didn't do the investigation, and at that point, the investigation had not begun, right?
I initiated the investigation, and then I turned it over to Deputy Taylor.
So you did do some of the investigation then, right?
Yeah, I explained that.
Well, no, I'm just clarifying because you said you didn't do the investigation. Deputy Taylor did the investigation.
My observations of him, and then leading up to the conversation, that investigation, then turning over the investigation to Deputy Taylor.
Okay, so my question is, how could you be sure, or what made you think that Mr. Marvin had consumed what it was you were smelling that you thought was intoxicating or smelled like intoxicants?
That's why we do it. You've asked. That's why we do the investigation. It led to that.
Right. I've asked the question several times because it's yes or no, and you have not indicated.
Because there's not a yes or no answer. It's the totality of the investigation leading to it.
So before you handed off the investigation to Deputy Taylor, what made you believe that Mr. Marvin had consumed something intoxicating as opposed to just smelling?
I'm going to object. He's answered this question like 5 separate times. He's went through all of his observations, I think 3 or 4 times already.
So counsel, I mean, the deputies testified that his suspicions were aroused by the smell of intoxicants. And so he directed Deputy Taylor to conduct an investigation. So I'm not sure how you want him to answer. I think he's already answered your question as I'm here. You're asking what led him to believe that your client had consumed intoxicants, and he's testified that it was the smell of bloodshot, watery eyes, slurred speech, and leaning against the walls. So I'm not sure what other information you're looking for, counsel. Can you clarify your question, maybe?
Well, I guess the court explained it, but I was trying to elicit the testimony from the witness as to what made him believe Mr. Marvin actually consumed what he was smelling, as opposed to.
Are you saying as opposed to him spilling intoxicants on him or smelling like that for some other reason other than that he actually drank it?
Correct, and it could be anything from gasoline, to a vodka. We don't know. No one's testified as to what it was for sure, but
Is from a legal standpoint, is an officer required to specify what type of alcohol he believes someone has drank before they can initiate a OWI investigation?
no, Your Honor, but I think it would,
So that the question is irrelevant then. So I'm going to ask you to move on to the next question.
okay. You also testified that Mr. Marvin was, how would you put it, rude when he came into the office to confer with Ms. Hall, right?
That's what, I wasn't in the room when that actually occurred, but.
So when you showed up with Mr. Marvin, Miss Hall, was he acting, in your opinion, disorderly? Is that how you put it?
He was acting, I would say, a little bit of a belligerent and little, when I asked him some questions, he refused to answer some questions. And I wasn't really quite sure what he wanted because I couldn't really understand what he was saying with his slurred speech and like being confused of what he was trying to say. I couldn't understand what he was trying to figure out.
And I asked if you were agitated. From your observations, he seemed pretty agitated, right?
Did he seem pretty agitated?
Mr. Marvin, right.
I mean, yeah, a little
bit. He seemed agitated because he couldn't get the information he was looking for, right?
Well, I don't know why he would have been. I know that he had called the office many, many times leading up to this day, and I spoke with him that morning.
And were your conversations productive that morning?
No. He was very argumentative, and I wasn't quite sure what he was trying to get.
Mr. Marvin being pretty agitated after, a long day of trying to get this information, that could have contributed to his slurred speech, as you put it, right?
No.
I have no further questions, Your Honor. Thank you.
Thank you. Ms. Koch, do you have any follow-up questions?
No, Your Honor.
Okay. Any additional witnesses, Ms. Koch?
No, Your Honor.
All right. Koch, anything by way of argument?
I think that's a little confusing the way the motion's written because it's titled a motion to quash the search warrant. I've already sort of went through the law on that, but at a suppression hearing, the burden of proof is on me. It's preponderance of the evidence. We must review the magistrate's decision, in this case, Magistrate Craig's, to issue a search warrant involving whether a reasonably cautioned person would have concluded that there was a substantial basis for a finding of probable cause. I think it's quite clear. We went through the entire affidavit and search warrant. All of the allegations in here were personally observed by Deputy Taylor. There is no allegations made by the opposing party, Mr. Marvin's counsel, that there is any deliberate falsehood or that there actually is any falsehood, deliberate or otherwise, that there's any reckless disregard for the truth. And there's been no proof whatsoever that anything in here was inaccurate. This investigation started because Mr. Marvin decided to drive up to the sheriff's department to try to find information about another time that he had called 911 when he was intoxicated. He drove to the sheriff's office drunk. Detective Clapadlo observed him that smell like alcohol, have bloodshot eyes, have watery eyes, slurred speech. He then asked Deputy Taylor to take over and do an OWI investigation. So even if he had an allergy to grass, poured alcohol all over himself and not consumed it, at that point he would not have had the signs, an SFST test that he was intoxicated. He did. Deputy Taylor went through all of those. He had the HGN. All 6 clues were present. And Deputy Taylor observed more of the same things that Detective Clapadlo observed, as well as Mr. Marvin indicating he had been consuming alcohol that morning. All of those things led to an arrest. He has the right to a PBT. If he wants one, he refused it, which is his right to do so. That would have at that time confirmed Deputy Taylor's suspicion and probable cause based on all the things he saw, but he chose not to. There was a search warrant done. It was signed by Magistrate Craig, and the results showed what both Detective Capello and Deputy Taylor thought to be true, that Mr. Marvin was over twice the legal limit. So I'd ask the court to deny the defendant's motion and proceed to the jury trial next week. Thank you.
Thank you. Mr. Shervin, any argument?
Yes, Your Honor, thank you. I just want to point out that this is really not a situation or a case where law enforcement were responding to a crime that had been committed. I'm sure the court's well aware of our federal and state constitutional rights against unreasonable searches and seizures, and it's nice to be able to walk around even into government buildings where folks investigate crimes like Deputy Taylor and the detective without being investigated for crimes that there's no reasonable suspicion for yet. Rather, this is a case where they had a suspect and they were looking for a crime. So I think that distinction is important because there must be a basis to prompt some sort of investigation into whether or not someone like Mr. Marvin has committed a crime, and that's exactly what happened here. Mr. Marvin voluntarily went to a government office to look for information. He wasn't taken there in a police cruiser or summoned there by a warrant, but he showed up on his own volition, hoping for answers. And he had spoken with the detective earlier that day, and from his point of view, things could get completely resolved if he showed up in person. I'm sure he was very anxious when he showed up, but he wasn't met with information or help or any sort of customer service. He was just met with agitation and patience and a full-fledged investigation into whether he had been intoxicated when he drove to the sheriff's department. And I think if this case is going to go to trial, that the state should have to use evidence fairly obtained, admissible evidence in the testimony of the officers, not evidence obtained as a result of a prolonged essentially a prolonged Terry stop, which turned into a full-fledged OWI investigation between two officers, one of which didn't even personally observe the suspicions that led to the investigation that the detective instructed Deputy Taylor to begin. And Deputy Taylor's results, even after the Terry stop, even if we're just challenging whether there was probable cause or not, Deputy Taylor's field sobriety tests on Mr. Marvin were inconclusive in my opinion, and there were no results from a PBT to confirm whether or not they had the basis they needed to arrest Mr. Marvin, resulting in the evidence my client's asking this court to suppress for use at trial. So the evidence of the open intoxicants inside of the vehicle that they searched to arrest, the BAC results, and the warrant allowing officers to obtain the BAC results from Mr. Marvin, because in these sort of situations, the court has to balance the privacy interest of someone like Mr. Marvin and the public interest of investigating crimes such as operating a vehicle while intoxicated. If Mr. Marvin was disorderly, then he could have been issued a citation for that, but rather they had Mr. Marvin in a government building where they wanted him to be, agitated, started looking for new crimes to allege that he had committed rather than addressing the one that was right in front of them. And it should not take several hours to address a disorderly conduct, which Deputy Taylor testified is not uncommon, not an uncommon situation. So I believe it could have been dealt with in a much better manner, considering Mr. Marvin's privacy interest and making them as important as they should be. So for those reasons, Your Honor, based on the testimony of the witnesses today, I would ask this court to quash the search warrant for Mr. Marvin's BAC results, the BAC results themselves, and the evidence obtained from Mr. Marvin's vehicle incident to the arrest that Mr. Marvin's motion alleges there was no probable cause for. And any other relief this court believes is fair and equitable under the circumstances. Thank you, Your Honor.
All right, thank you. I did have a chance to review the written submissions of the parties. Obviously, I heard the testimony here on the record today and the arguments made by counsel orally. I think one of the difficulties here is, Mr. Sherman, your argument isn't really well focused. The motion isn't really well focused. It's kind of all over the place. You're raising, issues of the search warrant, whether that was justified, issues regarding the search of the vehicle, questioning whether the officers had probable cause in the first place to even start an investigation, let alone conduct an arrest. Here on the record, you're raising Terry issues, which weren't part of your motion or brief. So you kind of set out a moving target here. And I think the prosecutor kind of alluded to that in her argument where, she thought we were arguing over the search warrant here and whether or not that was validly signed by the magistrate, properly executed for Mr. Marvin's blood. And some of your argument doesn't make sense in relation to the facts here. You seem to be arguing that somehow the police were engaging in this investigation as retribution for Mr. Marvin coming to the police department or to the sheriff's department that day. Mr. Marvin, as you said, voluntarily came to the sheriff's department. It's not like the police went out and arrested him or, sought him out for an investigation. And based on the testimony that I heard today, the only reason why they started an investigation is because of Mr. Marvin's own actions when he did come to the sheriff's department. His actions in being belligerent towards the administrative staff, which wouldn't have had anything to do with the investigation anyway. But more importantly, the officer's observations when he presented himself to the sheriff's department, when Officer Copadlo first encountered him. So, in terms of trying to identify the legal standard that the court's to apply here, I'm gonna look at this from a number of different ways to try and cover all the bases I think that you've raised sort of at various times. Number one, was there probable cause for an investigation kind of under that Terry standard? Did the officers have reasonable suspicion to detain Mr. Marvin and conduct an investigation? Was there sufficient evidence for the officers to believe that there was a crime afoot that needed to be investigated? So what evidence do we have of that? Deputy Copadlo testified that when he interacted with Mr. Marvin, that he immediately, through the hole in the glass, smelled the odor of intoxicants. I don't think that the prosecutor is required to show that they identified any particular intoxicant. I don't even think they're required to show that an intoxicant was actually consumed. Again, we're looking at reasonable suspicion here. Does the officer have an articulable reason to investigate further? And the smell of intoxicants, particularly from an individual who's acting in the way that the officer testified Mr. Marvin was acting, I think any reasonable person using a common sense standard would think, okay, maybe there's something going on here that should be investigated. The officer confirmed that Mr. Marvin had driven to the sheriff's department in a vehicle on his own. And so that, given the officer's observations, I think, is reasonable suspicion to conduct an investigation and to detain Mr. Marvin. So then Detective Copadlo advises Deputy Taylor of his observations, asks him to conduct an investigation, which Deputy Taylor does. Mr. Sherman argued here that Deputy Taylor was going only on Deputy Copadlo's observations, but that's not true. Deputy Taylor testified that he himself witnessed all the same attributes that Deputy Copadlo witnessed, and that is that Mr. Marvin smelled of intoxicants, that he had glassy eyes, bloodshot eyes, that he seemed flushed, that he was swaying, and that his speech seemed confused, and that he was generally acting in a disorderly way. So I think, again, there's a justification for the beginning of an investigation here based on Detective Copadlo's observations. So then does Deputy Taylor have probable cause to arrest Mr. Marvin? So Deputy Taylor has those observations that I just indicated, all of which he testified that his training and experience are indicators of intoxication by alcohol. Deputy Taylor then conducts field sobriety tests, standard field sobriety tests, at least one of which Mr. Marvin performed okay on, but two of which he did not, including the horizontal gaze nystagmus test, in which he showed all 6 clues. And so based on Deputy Taylor's observations of Mr. Marvin, combined with the results of the field sobriety test, Deputy Taylor concludes that he's going to request PBT, which Mr. Marvin refuses, which, as everybody's acknowledged, is his right to do. So while a PBT can be an additional piece of evidence, along with observations and field sobriety test results, again, contrary to defense counsel's argument, I don't think there's any requirement that a blood alcohol level or a PBT be conducted in order to arrest somebody for OWI. So I don't think Deputy Taylor had to conduct a PBT before he could have probable cause to arrest. I think, again, under a common sense standard based on all the information that Deputy Taylor had, including his own personal observations, he concluded that there was probable cause in that there was, from the totality of circumstances, a reasonably cautious person, a reasonably prudent person who believed that an OWI had been committed and that the defendant had committed it. So I think at that point, Deputy Taylor has probable cause to conduct an arrest of Mr. Marvin. Deputy Taylor then takes the extra step of requesting a blood test, which Mr. Marvin initially agreed to and then withdrew his consent. So at that point, Deputy Taylor takes what I view as the appropriate action, which is to seek a search warrant. There hasn't been any challenge by the defense as to the validity of that search warrant, even though that was challenged as part of the motion. But there hasn't been any indication that that affidavit was filled out incorrectly, that it was based on something other than Deputy Taylor's observations, or that the magistrate did not have an appropriate legal basis to sign that search warrant. So in my view, the search warrant was properly applied for, it was properly signed, it was executed, and of course, Mr. Marvin was eventually charged based on the results of that blood test, which was well over the legal limit. In terms of the search of Mr. Marvin's vehicle, deputy testified that after Mr. Marvin was arrested, that they conducted both a probable cause search of his vehicle as well as an inventory search. Inventory searches are certainly appropriate when they're made incident to an arrest and pursuant to a department policy, which Deputy Taylor testified did conducted pursuant to the department policy. So even if there was no probable cause, there was a basis for the search of Mr. Marvin's vehicle, incident to his arrest. So the court finds, really given the totality of the circumstances here, there was more than enough evidence based on the observations of the officers to conclude that Mr. Marvin was intoxicated under a probable cause standard. Now, of course, that's much different than what the prosecutor has to prove at trial. The prosecutor has to prove it beyond a reasonable doubt, and the defense is free to raise arguments such as allergies or physical disability and so forth, or that Mr. Marvin poured alcohol over himself, and that's what led to the smell. But those are all arguments that would be raised at trial. None of those defeat what would be probable cause for the officers to either begin an investigation, to conduct an arrest, and to obtain a search warrant. So again, the court finds under a probable cause standard, there's more than enough evidence to support all of that. So the court will deny the motion and we'll proceed with trial as currently scheduled, I believe next Monday morning. Mr. Sherbin, anything else we need to address for the record today?
Yes, Your Honor, I did submit a request to, it's a form your office has to review the potential juror list. I was hoping that the court could address that today as well.
I did believe I signed that approving it, Sarah?
Yep, good. I sent that up yesterday. I did, there's also the prosecutor's request in Jen's email for you as well. So you have both of those.
Okay, so Mr. Sherbin, the court will, for the record, I'll approve it, but I'll also sign that form once it's been presented.
Thank you, Your Honor. Is that available to be sent by email, or do I have to pick that up in person at the clerk's office?
Sarah?
The order or the jury questionnaires?
The jury questionnaires.
You would have to pick those up in person.
Okay, thank you.
You're welcome.
All right, Ms. Koch, anything further from your side today?
Your Honor, I'm just going to put this on the record. It doesn't really need to be addressed by the court, but I want to make sure that defense counsel and the court are aware of it. There were some questions today that I really tried to avoid going into, but it may be a problem at trial. If defense counsel tries to bring in why the defendant was there, he was trying to get information about a situation where he was drunk the month before and called 911 repeatedly. The deputies responded and he was drunk. He was mad that his wife wouldn't give him the keys because he wanted to leave the situation, and he was calling the cops all kinds of names. I'm going to try to avoid that, as well as his drunk driving history, which is pretty substantial. He has 3 prior convictions already, but they were asking questions like, do you know if he's a functioning alcoholic? Do you have any information about that? Do you know what information he was trying to get? So I'm going to instruct my officers the best I can to avoid answering the questions with any of the information regarding Mr. Marvin's lengthy history of alcohol abuse and his contact with law enforcement because of his alcohol abuse. But if he asks very specific questions, he's going to open the door to that situation. So I will do my best to inform both officers to try to stay away from that. But I'm letting the court know if the defense counsel opens the door, it's probably going to come out. So I'd like to avoid that. I didn't file a 404B. I don't think it's appropriate for it to come in. But if defense counsel does ask the wrong questions, we're going to have a real problem on our hands. So I'm just letting everyone know that may be a potential issue.
All right. I mean, I appreciate that. I don't think there's anything that I can rule on right now, but both counsel, I guess, need to be aware of and carefully craft, each of you craft your questions. But it is what it is. I have no idea how things are going to come in. The court will rule accordingly.
Thank you.
All right, that's all for today. All parties are free to disconnect at this time.
Judge, before you go, I am not sure if you have a copy of the order after the hearing. If you don't, I can email it up as I have a copy in the file.
Yes, please do. Thank you. I don't have a copy of that.
Okay, I will send that up.
Okay, thank you. That's all for today.